not technology experts, but welcome to our webinar. I am Deborah Cardisser from 12 Points Wealth Management, and I'm joined today by Deborah Hedges. And what we wanted to talk to you about are the essentials of estate planning. And I just want to tell you what this is coming from in terms of what we're doing here and what we're trying to promote. So at the 12 Points Center for Women, we are trying to make content and financial advice and financial know-how available to everybody. So whether you're a client or not, we want to make information available, and that's the purpose of these webinars, is to reach people who may not be my client or Deb's client, but can get advice and learn what they need to know in order to set up their finances appropriately. So I'm a senior wealth manager here at 12 Points, and my role is to help people to set up their finances to support their goals and to expand their current vision of the future, because they're capable and probably able to create more than they know. So my personal mission is driven from my experience as a young parent, a new parent with a 12-month-old child. I was thrust into the medical world for 10 years with him, and he's fine now, but what I'm committed to professionally is to build for my clients and other people what I didn't have then, which is a guide to help manage and teach people what they need to know so they can make informed choices. So I'm joined here today by Deb Hedges, and I'd love you to introduce yourself and tell us about your personal mission and all of what you do.
Well, thank you, Deb, for inviting me today. I'm excited to be joining. I'm an estate planning attorney. I live in Medfield. I've been practicing for about 15 years. I've been through a lot of what you're sharing right now, and the importance of this program. It's deeply personal to me. I'm a mom of 2 college-age kids, but I lost my husband 10 years ago to cancer. And during that experience, I was an estate planning attorney, but also I just really learned to understand that life is unpredictable, and it's really important to have your affairs in order, and how having the time to be able to spend with your family during this, instead of worrying about your finances and worrying about your legal documents, it's just really important if you're prepared. And there's really no specific age to be prepared. I think everyone at any time needs to have these in order. And then also, just for me, once after my husband passed away, I raised my kids for several years, but then I returned to estate planning because I just understood the importance of it and how I could be empathetic. And really, I find it so important to be approachable and be able to explain these documents and what is needed to be prepared for whatever life presents.
Great, thank you so much. Really appreciate you joining us today. And oops, I've advanced my slides. So I wanted to help people to understand that estate planning is a necessity for everybody, whether you're wealthy or not, whether you have children or don't. Everybody needs an estate plan. And Deb is going to help us go into exactly why and what happens when you don't. But really, we're going to go over today the essential documents. What is a power of attorney, advanced medical directives, the HIPAA authorization, and a will, and then going through situations where you might need or want a trust and the difference between living trusts and revocable trusts. So the other thing that I want to point out here is to have people understand that doing this through LegalZoom or through some online process is not your best bet. Going to a professional who does this for a living, this is their sole role in the world, is to do this is super important, and getting that expertise and advice will serve you on the other end of things and help your family. So I want to talk first about the durable power of attorney, and this is really the ability while you're alive, which is really important. It's not after you die, but this is just granting an individual, you can call them an agent or attorney in fact in the document, but it gives them the legal authority to make decisions on your behalf. And decisions can be related to legal or financial matters, but this is not healthcare. This is legal and finance. And there are different types. So Deb, please tell us what goes on here and when you would use what?
Right, so there's several different types of powers of attorney. The one I use most often is the durable power of attorney. So this is something that goes into effect immediately once you sign this document. So even though you have full capacity, you're naming your agent or your attorney, in fact, to be able to help you with your financial and legal affairs. But it's durable. What that means that it remains in effect even after you become incapacitated. So for most of our clients, this is the document that we use primarily because it allows, if you name your agent, and even if you just are not able to go to a bank or deal with a financial institution, but you have capacity, your agent can help you on your behalf. So this is something that would exist throughout your lifetime and would expire upon your passing. A non-durable power of attorney is a little bit different, only that it usually only is in effect if you have capacity. It does not go into effect if you are incapacitated. So that's really the big difference between those two. Oftentimes it's used for a purpose. So if I needed someone to attend a closing for me on my behalf, that they could sign closing documents for a real estate purchase, that would be something that I would use a non-durable power of attorney, and that agent would only be able to act for that specific purpose. There's also limited ones that allows your agent to, again, act only under certain circumstances. And then the springing power of attorney, again, this one takes place often, if you become incapacitated, then it goes into effect. So you sign it now, but it only really goes into effect on the event that you become incapacitated. And as the slide explains, sometimes this requires doctor notification about when the time comes when you are determined to be incapacitated.
So as a financial person working with these documents, we find that a lot of the financial institutions don't like to use a legal document. They like their own form signed. Tell us about, and we've run into problems with the institutions saying, well, this is too old. So talk to us about how often people should be signing these and keeping them sort of refreshed.
When you sign one, typically, there's not an expiration date, but more and more we're seeing that financial institutions are being a little bit more particular about the dates. So we recommend to our clients that they update these really every 3 to 5 years, even if your agents aren't changing, but just to have fresh dates on these documents. There's just so much fraud right now going on, and there's a lot of liability that financial institutions are concerned about. So they want to see current dates. If you have a document that's 20 years old, it still technically might be valid, but that doesn't force an institution to accept it. So that is why it's really important to have current documents,
so
especially the power of attorney.
Sorry. Another thing to point out is look at your parents' documents and make sure that they're keeping theirs refreshed. So yours and theirs as well.
Yes.
So then in terms of healthcare directives, talk to us about what this does. And this is different, obviously, from the power of attorney that does legal and financial. This is the healthcare part of things. So talk to us a little bit about this and how it works.
So a healthcare proxy is different in that it, first of all, obviously deals with health decisions. So in Massachusetts, it's a statutory document. And there's some specific requirements the document needs to have, such as 2 witnesses and a notary. And this is a document where you're naming your agent to be able to make medical decisions for you on your behalf if you're not able to do it. So it's that, this is something that I feel like every person should have, because you just never know when the circumstances could come up where you would need someone to make a decision, and you would like to be able to choose that person that you trust, and also someone that can handle those decisions. Oftentimes we'll have clients that, think about naming a young adult a child who's in their early 20s. And we always just discuss this because even though, yes, they are able to make this decision, is this a decision you would want them to make? And maybe naming someone that's a little bit more mature and capable of making tough decisions. So that's the healthcare proxy. And then the living will is another document that goes with this. A living will is different, however, because in Massachusetts, a living will isn't really a legally enforceable document. It's more of a guideline. And this is something that it's a very personal choice. Some of our clients opt to do these and some do not. But this is a decision that everyone makes about whether or not they would like to be kept alive artificially if they're in a circumstance where they're on being kept alive by machines. It's, for example, if you were on life support, whether or not you would like to have those life prolonging measures removed. So this is a guideline that your healthcare proxy actually would be the one to present that document if you sign it to the doctors. So these two documents work together.
So again, something to dust off and refresh yourself on given your current state of health. And then do you give copies of these to the person that you've appointed and to your doctors?
Yes. And so we typically recommend the healthcare proxy, the living will, and the next slide we'll talk about the HIPAA authorization. Those three documents, we do recommend our clients bring the updated documents once they've been signed to their primary care physician. They'll typically take a copy and then they can upload it to their portal, and so all their doctors within their network can see these documents. And once you execute documents, especially if they've been prepared by an attorney, we recommend you don't sign new ones with a hospital or a doctor that they might present to you, because typically the ones prepared by an attorney are more comprehensive and are better to address some of the concerns than one that a hospital or a doctor would provide.
That's great. And then I think the important thing to point out here is that the HIPAA authorization, there's no order of preference, the way you can assign them with your medical directives, so that this one, or your healthcare proxy, so that this one gives everybody equal access.
Right. And we often so again, if we had a client that wanted to name and had children that were in their 20s and they wanted to name them, this is a document that, of course, you might want to name your children in this, because this just allows them to have access to your information to speak to medical personnel about your care. So this, you could name certain people in the HIPAA release that you would not name to make medical decisions. So this is a little bit different. This is just allowing them to have access to information, but not actually make decisions.
Great. So everybody has heard of a will, and really this is a document dictating how you're going to distribute the assets when you die. So it allows you to appoint a guardian for your children. It allows you to appoint and make provisions for a pet, and take care of tangible personal property. So people throw that term around. That means assets you can touch, whether it's jewelry or artwork or an automobile collection. Those kinds of things are tangible personal property and not assets that sit in a bank or some institution. And the really important thing here to point out is that if you don't have a will, the state decides what happens to your assets, and you lose your ability to control that. So this is something that everybody needs. So talk a little bit about, if you would, the appointments that you make and how that all works in the document.
So in the will, right, so you would first name your beneficiaries, as you mentioned. So that would be who would receive your assets on your death. And that can be a family member, friends, whoever you choose. It could be a charitable organization. So you name your beneficiaries. Then the next role would be the personal representative. It's also the same thing as the executor. So this is the person whose job would be to gather your assets and make these distributions according to your wishes. It's also often the person that would sign your final tax returns. So it's somebody that has to be most likely organized and able to follow direction. It's also the document where you would name your guardian. So your guardian could be a completely different person than from the personal representative. So the guardian would be who you want to care for your children. This is so important to include because you do not want the state to be able to make the decisions as to who would care for your children if they're under the age of 18 if you were not able to. So that's why it's just so important to have this document prepared, especially with young children. And it's just also the document, as Deborah had stated, that you get to decide where your assets go versus the state and what the state thinks you would want. You want to be able to make these decisions and control the ultimate distribution of your assets.
Yeah, that's great. And making sure that you've got guardians in place. And Deb, talk about how you, we were talking about this yesterday, how you help young families and the guardianship.
As far as young families naming guardians?
Naming guardians, and then sort of making sure that kids don't end up at, DSS overnight whilst the guardian's coming from far away.
Right. Yeah. So Massachusetts, there's a couple different things. In Massachusetts, you would name your guardian in your will, but you would also name your guardian in separate statutory forms. And one of the forms that we create, which we think is just so important, is that you name a permanent guardian. So in the event that you or the parents are not able to care for their children if they passed away or become incapacitated, but we also do temporary guardianships. And that's something that's we find more and more has been important, especially during COVID. Often both parents might have been hospitalized. So these are documents where you would name somebody up to 60 days that could have a temporary care for your children if you're not able to care for them. And this would also include a HIPAA authorization so that whoever is caring for your children during this temporary time can also make medical decisions. So these two documents are, both important, the permanent and the temporary guardianship forms.
And this is why you don't go to LegalZoom. Just the coordination of all the documents and making sure that everything is set up and that all these pieces are sort of addressed and accounted for.
Yeah, and the other thing just to mention also is the conversation with an attorney about these decisions, because oftentimes we'll have clients come in and they'll say, I want my sister, and then we say, well, is your sister married? Well, maybe you'd want to name both of them, but then what happens if they're not together, if they're divorced, if there's a death? So these are all the considerations that sometimes people haven't thought through all of these decisions, and you really want to make it very clear in the document, because oftentimes you might say, I want this couple, but yes, if they were divorced, I would want one person versus the other to have the ability to be guardian if they're no longer married. So these are all just the considerations that should be made when you make such an important decision.
That's great. So I love your terminology here, the pit. You want to avoid the pit. So that is probate, inheritance problems, and taxes. Now, you can't avoid taxes, but there are things you can do to mitigate them a bit here and there. But I'd love to have you talk about the probate process, because this to me is something to be avoided at all costs. But love to hear your take and talk about what happens. So probate happens with a will. If you have a will, you'll go through the probate process. The way to avoid probate, we'll talk about in a little bit, is to have a trust. But talk a little bit about what probate means and what these three things are that constitute the pit.
Sure. So probate is a process that involves the probate court. So anything that you own at your death that's in your name would go through probate if you don't have a beneficiary designation. So things like your 401k, retirement assets, maybe life insurance, those hopefully if you have those assets, you've named a beneficiary. So those would avoid probate, because at your death, those assets would pass directly to a beneficiary. But anything that you own in your name that does not have a beneficiary designation would go through probate. So that would be things like your home, maybe a bank account, your tangible property. So those items would go through probate. What that means is if you just had a will, your will would be brought to the probate court. The court would have to approve your will and make sure it's valid, and then issue letters of authority for your personal representative in order for them to be able to manage those assets. This takes time. Anything that involves the probate court is usually going to be lengthy. Oftentimes you're going to have an attorney that helps you to bring the document to the court, to deal with any of the court proceedings. It's also a lengthy process because it needs to be open for long enough for creditors to come out of the woodwork and make claims. And one of the biggest things is also public. So having it as a public process just means that anyone that can go onto the probate court docket and see the actual will, see who your beneficiaries are. In my own personal experience, luckily most of my assets, or actually none of my assets when my husband passed away, went through probate. But there are people that are out there that will look at obituaries, look up your address, reach out to you. I had Facebook messages. I would get mailings because people saw that I had lost my spouse, and to have it documented as a will that names your guardians also be public is opens you up to a lot of creditors out there. So it's just something that most people would like to avoid if possible.
Yes. So, and I've seen that happen, and it's really awful when you're going through a devastating time to have people who are ambulance chasers and whatever other terminology there is after you and calling you. And yeah, very difficult. So the probate process, I think what you talked about earlier, the time delay is really critical. So let's say someone has died. Let's make it a parent just to make this easy. It's your last parent. You've got to take care of their last debts, paying off their funeral and those kinds of things. And you may not have access to their money for a while if you're their if you're their personal representative. So I think that it's important to understand that the probate process is a delay. You've talked about the open to creditors and the execution of the estate. Then once you get access to it and you can re-register things, then you can start distributing assets. But this all takes a lot of time.
It does. And for example, if you have a bank account and you want to have access to it as the personal representative to pay bills, to pay the mortgage before the house is sold, to pay the insurance, without a letter of authority from the court, most banks, or almost every bank, is not going to let you have access to those accounts. And so that can take a couple months. So it's almost as if these assets are frozen. You can't really have full access to them. You can't sell a home. You can't have access to the cash without going through the probate process. So you're at the mercy of the court and the length of time it takes. During COVID, it was even much longer of a process because the courts were shut down. So we had clients calling, trying to access accounts, and our hands were tied because banks were not allowing them to access them because they didn't have the letter that the bank would require for the permission to go forward as a personal representative. So it's really just you're at the will of the court and when they have the time to issue these letters.
So I think the important thing to point out here is ways to avoid this. Let's say it is a parent that we're talking about in the example. Having a joint account that you have access to allow you to access some of the money that you're going to need to pay the bills is a way around that, or something that you can do. It's not a blanket sort of solution for this because there are estate issues with that we'll get into in a minute, estate tax issues. But beneficiary designations can help with some of that. You can do a transfer on death designation, again, not recommended for all your assets, and also trusts, which we'll get into in a minute. So talk to us about what we want our estate plans to do, and I love your term here, the killer deeds.
So the killer deeds is something that we created just to make it very clear how there are different types of trusts. And most of the trusts that we're talking about today, there's two large categories, and we'll get into that in a moment, the difference between revocable and irrevocable. But one of the pits of regarding inheritance is inheritance protection. So a lot of people, or a lot of estate plans have inheritances going outright to your beneficiaries. That's very typical, maybe at a certain age, but once that beneficiary receives this inheritance, it's their money and it's therefore vulnerable to third parties, to outsiders. So one of the types of trusts that we create are called these inheritance trusts. What that means is at your death, when it goes down to your children, instead of it going outright to your children, it goes into an inheritance trust. These trusts are created at your death for the next generation. And these trusts are irrevocable because, again, you've now passed away. You've created the trust. The beneficiary is the next generation. And because these are irrevocable trusts, they protect against what we call the killer Ds: divorce, debt collection, disputes, disability, death taxes, and destructive habits. So those are all the killers to an inheritance, these killer Ds. So these are an inheritance trust is a way to provide for your loved ones, to pass wealth down to the next generation, but instead of giving it to them directly, it's giving it to them in a protective environment where they're protected from these we call them the killers to an inheritance, killer Ds.
Well, and I think it's so helpful when parents explain to their children why they're putting assets in trust. So if you do adopt this plan, you've got choices. It's outright to the children or it's in trust. And if you do opt for the trust, explaining why it can be very helpful. It doesn't mean you don't trust your kids. It doesn't mean they're not responsible. It's just simply an added layer of protection that can really help them.
Yes, exactly.
So I want to talk about estate taxes because it's so important, and it does matter, and it does dictate, I think, how you do your documents and what you set up for people. And the one thing that I want people to understand is we've got these exclusions from federal taxes and from state taxes. And these exclusions are obviously very different numbers. It's 2 million per person in Massachusetts, and it's almost 14 million federally. So very big numbers on the federal side, much smaller numbers on the Massachusetts side. On the federal side, there's portability. So if I'm part of a married couple, we can shift assets back and forth. And as long as we make the right election at somebody's death, it doesn't really matter who owns what or how they're registered. But on the Massachusetts side, it really does matter. So talk to us a little bit about that and the fact that there's no portability and how it impacts an estate.
Right. So in Massachusetts, because there's no portability, you really have to plan in advance in order to be able to take advantage of each of your exemption amounts. So as you stated, Deborah, there's a $2 million exemption for everybody in Massachusetts. We almost look at this as like a coupon. So if you're a Massachusetts resident, you're born and you raised and you live here and you die here, you have this coupon for $2 million of protection against estate taxes. So anything you own above that $2 million is going to be subject to a Massachusetts estate tax. The range is around from 8 to 16%, depending on how far above this $2 million range you go. So if you're in a married couple and the husband has $2 million and the wife has a $2 million exemption, with proper planning, you can take advantage of both of your exemption amount. Without proper planning, what often happens is when the first spouse passes away, everything passes to the surviving spouse. There's no tax at that point. There's no tax and the transfer between spouses. But when the second spouse passes away, they're only able to use their $2 million exemption. There's no portability of what the first spouse had left. So what happens is you might only be able to use a $2 million exemption for as a married couple for your assets. And you've lost the first spouse's $2 million exemption. So it's kind of complicated the way it works, but with proper planning, trust can prepare when one spouse passes away, they allocate some assets to the first spouse and allocate some assets to the second spouse. By doing this, creating what we call subtrusts or credit sheltered subtrusts, we're able to use the exemption from both spouses. So instead of it being $2 million that you're able to use as a couple, you're able to use $4 million of exemption amount. So it really can make a huge difference for your beneficiaries ultimately, because they're going to be paying a lot less estate tax if they do the proper planning.
Yeah, so this is such an important message, and the bottom line is if you have more than $2 million in assets, you should be really talking to an estate planning attorney. You should be anyway, but to really help you with this, to make sure that you're going to maximize your exemptions. And, it doesn't take much to get to the $2 million level if you're sort of middle-aged or more, with a house in Massachusetts or anywhere for that matter, but a house, a car, and a retirement account that you've been saving in for a couple of decades, you can get there pretty quickly. So
right, and on your death, Massachusetts, they count everything. So it's your investment accounts, it's your property in Massachusetts, it's your life insurance, it's your bank accounts, it's everything that you have is added up. So you can get to there pretty quickly. And we should also just mention, that there is the federal estate tax, much, much higher exemption amount. So, most people do not have to worry about this, but it is going to end. It's going to change. The numbers are going to change at the end of 2025, depending on the administration and if there's any change in that. So right now it's 13.99 million per person. It's going to go down to about 5.5 million adjusted for inflation, which we expect to be around 7 million per person. So it's significantly less. So for a married couple, that would be $14 million. Again, most of us don't have to worry about that, but there are a lot of people that if you add up all of your assets, especially over time, you might get to that. And for the federal rates, it's 40%. So it's a much higher rate of the state taxes. So one of the things that some of our clients are doing in anticipation of this sunset, of this reduction in the amount from 14 million to 7 million, is doing lifetime gifting. So there are some things that you can try to do, of course, speaking with an estate planning attorney, to try to take advantage of this high exemption amount right now on the federal level before it could change in the future. Whether it changes now, this year, or changes sometime in the future, there are ways to take advantage of that $14 million exemption and lock some of that in now.
And this is where having a team of financial advisor and estate planning attorney works so well, because they're in communication with each other. They can help with the plan and execute it together. And the coordination of information flow is so much better, and you're likely to end up with a much better result. So definitely employ your people and create a team. So let's talk about trusts for a minute and sort of the basic terms of the trust here, and then just basically how they function.
Sure. So there's really three major roles in a trust, either whether it's revocable or irrevocable. The first is the grantor. So that's the person that creates the trust. That's the one that comes up with the terms, what their wishes are, who the beneficiaries are. So this is something that the grantor is the one that creates the trust and expresses their wishes. A trustee is the person, or it could be an entity, that carries out the terms of the trust. So following what the grantor puts into the trust, the trustee is the one that manages it and follows this. Oftentimes, it can be the grantor and the trustee are the same person, especially for revocable trust. During your lifetime, you might be the one that creates the trust, and you might be the one that manages the trust. And then finally, the beneficiary. So that's who the intended heirs are, who are going to receive the assets during your lifetime and at your death. So again, and we'll touch on this in a moment, for a revocable trust, you could be the grantor, you could be the trustee and the beneficiary, because you're creating this trust for yourself, for your lifetime, and you're managing it as well.
Yeah, so I think the important thing to point out with the revocable trust, also called the living trust, is that it can be changed at any point during your lifetime. So people get worried about putting assets in trust. This, you can change at any time. So you pick up the phone, you'd go see Deb, she can revise your documents for you, and presto, it's changed, and you can change every facet of it. And it's important to understand that when you die, it does become irrevocable. So the terms of the trust then become irrevocable. Just because you create a living trust doesn't mean it stays that way, because it doesn't. And making sure that as you age, so think of your parents here, you're looking at co-trustees and making sure there's someone else who's appointed to serve with them. And if one of them's starting to fail and they're each other's co-trustee, it's time to get another family member appointed. So these are quick changes that your estate planning attorney can make for you. And but what we want to do here, what makes it so important and good for the grantor, is that it does avoid probate. It keeps your information for anything that's registered in that trust from becoming public information. And it helps if you ever become incapacitated, because you've got a co-trustee assigned. And so that co-trustee can take over and manage things for you. And unlike probate, when you die, if you have a co-trustee appointed, they seamlessly take over that trust for you. So you don't have to go through the process of having somebody appointed. It's all in those documents, and it's a continuous operation of the trust, which I think is really important. There isn't a tax savings for creating this entity itself. You can have estate tax savings when you die and this gets carried out, and Deb mentioned that before, but this is really to create seamless transfer and to make sure that your assets don't go through probate.
Yes, yep. And also just to, for a revocable living trust, there's no separate tax ID number. It follows your social security number. It's as if you own everything that's in the trust. It's your alter ego. So if you're the grantor of the trust and you're the trustee of the trust, during your lifetime, you're also the beneficiary. So they're, just like Deborah had said, there's no tax savings specifically just for a simple living trust, and there's no asset protection as well. So it's as if you own the assets that are in the trust. But again, the major benefit of a revocable trust is making things seamless, so that when you do pass away, there's no delay in waiting for a court to approve everything. Everything that's owned by the trust or paid into the trust at your death is going to be given to the trustee, and the trustee can immediately manage this. So also, I should have mentioned before, a well-drafted estate plan will always name successors. So if you're the trustee during your lifetime, it's always so important to name a successor trustee, so that if you become incapacitated or at your death, the next person in line is ready to go and can immediately take action and start doing their job as far as protecting the assets and also distributing their assets.
Yeah. So just to point out here, making sure we've got under the con side here, making sure that things are adequately funded, which means when you leave your estate planning attorney's office and you have your binder with your documents signed in there, you need to take them to your financial advisor and have or your attorney can help with this as well, have your accounts changed in terms of the registration. So if you've got the John Smith Trust, you're going to switch that over to the John Smith Revocable Trust. I'm sorry, John Smith Individual Account. You're going to change it to the John Smith Revocable Trust and make sure that those titles reflect the titles that you've got in your documents. So that's really, really important. And we see all the time that people have created these revocable trusts and never fund them. So that's sort of, the big pitfall of the next step, making sure that that takes place. So I want to talk about the irrevocable trusts here. And it's permanent. Once you put your assets into this entity, it's done, it's over, and you give up, in most cases, any ownership of those assets. So you're essentially taking them out of your estate. And this can be a great thing if you're doing estate tax planning and things like that. You may want to do that so that you're removing appreciation from your estate. But really need people to understand the difference between revocable and irrevocable is you can't get these assets back. So you can set them up in various ways. There's lots of different purposes for them in terms of flexibility or what you're trying to achieve, whether it's a life insurance trust and you're trying to take away your ownership of that so you don't get taxed on it. Different things that can have different objectives. And it's also about who you are, what your objectives are, and who your family members are. Maybe you're trying to protect a family member who has special needs. Maybe you're trying to protect from a family member who has addiction problems. So there's so many different types of trusts you can set up that can help you achieve your objectives here. But I'd love to have you just go over a little bit, just the pros and the cons of these and what people should be thinking about and what they can expect from this.
Yeah, and as you said, there are so many different types of irrevocable trusts. So we're just sort of giving you the general overview, but there's for different purposes. So each of them can be are unique. But some of the pros for an irrevocable trust is, as you mentioned, removing an asset from your estate. So if you put something into an irrevocable trust, one of the cons is you can't take it back. Once you put it in, you can't take it back. But if it is put into an irrevocable trust, and if you're not the trustee, you're no longer technically the owner of this asset, it will not be included in your estate. So if you have a larger asset or something, or an asset you think that might appreciate over time, if you put it into an irrevocable trust, there's ways to draft the document so that it's not going to be counted in your taxable estate when you pass away. That also can also offer some asset protection. If it's no longer your asset, there are ways to draft a trust to make sure that that the assets owned by this irrevocable trust are no longer considered yours. So if you were to be sued or anything like that, it would not be considered your asset. In Massachusetts, you can't create a trust for yourself and name your trust yourself as a beneficiary. In other states, you can. So there are different techniques. So that, if your primary goal is asset protection, there are ways of protecting some of your assets and still being a beneficiary. So again, that would require an estate planning attorney to help address those different needs. Also, a lot of our clients are thinking about long-term care if they're older in age and they're worrying about long-term care expenses and possibly applying for Medicaid benefits. There are types of trusts where you can put your home, for example, into an irrevocable trust. If it's in existence for more than 5 years and you have someone else other than yourself as a trustee, this asset could be outside of your countable assets for applying for Medicaid. So in Medicaid, if you're an individual person, and this is sort of getting into the details, but you can't have more than $2,000 of assets in your name. So a lot of our larger assets would be a home, for example. So you could put your home into a trust if the trust is in existence for more than 5 years and you are not the owner of the trust, so you're not the trustee of the trust, this asset wouldn't be counted as one of your assets when you apply for Medicaid. So there's all different types of irrevocable trusts that you can create depending on who you're trying to protect and what type of assets you're trying to protect. The cons, of course, are that once you put it in, again, you can't take it back. So once you've put it into a trust, it's irrevocable. You can't remove it. Most of the time, you can't be the trustee. So you have to have someone else manage the trust. trusted family member or an independent trustee are great options if you, if you're thinking of this type of trust. Typically, we don't put all of your assets into one type of irrevocable trust because most people want to have some control over their assets. So you're giving up control by creating this irrevocable trust. So oftentimes we have both a revocable trust and an irrevocable trust working together. Some assets are in one type of trust, some assets in the other trust. Also, you can't put any type of retirement assets into an irrevocable trust simply because you need to own your retirement assets. They're in your name, so you can't have a trust own them, whether it's revocable or not, actually. And then there's also some time limitations. So life insurance has a time limitation for their types of trusts, but also for the asset protection trust for Medicaid, there's, as I mentioned, a 5-year look back. So you need to plan in advance and think of these strategies, hopefully in advance before the need comes up while you're applying for Medicaid.
That's great. And just as an aside, the retirement assets, even though they don't go through your trust, you don't go through probate as long as you have a beneficiary assigned. There's sort of a workaround. It still gets counted in your estate, in your taxable estate, but it doesn't count as far as going through probate. So one of the things—
And they can be paid to your trust. They just can't be owned by the trust while you're alive.
Right, while you're alive. Yes, important distinction. So one thing that I think people are gaining more favor these days are prenuptial agreements and postnuptial, for that matter. You can also set up those. But really, it used to be back in the day that these were for wealthy men who wanted to protect themselves against divorce. And what we're seeing more is that there are more women now than men, actually, who are employing these agreements, and really it's for debt avoidance. If your partner carries a lot more debt than you do when you get married, beforehand you should think about things like this and put it in an agreement so you're not saddled with their debt. And it can be a way of protecting existing property. So if you have an inheritance, this is a great vehicle to set up in advance. If you have a business that you started but your spouse isn't a part of it, that's another thing that you might want to protect in a prenuptial agreement. And so talk to us a little bit about this and the kind of protection that it offers and what kinds of things people need to be thinking about as they set them up.
I mean, one of the first things is, of course, is to have an attorney draft these. These are important documents. So we've seen once or twice where someone has pulled this off of a website, online, doing a little Google search or using AI. It's really important to have these drafted accurately and professionally. And we always recommend, and that it's common practice for each party. So if you're getting married, for each of you to have your own independent attorney to draft these documents. So you're represented, make sure your rights are covered. And it's just, as you stated, Deborah, these are just more and more becoming very popular. They're not really considered as offensive as they used to be because it's just protecting your own assets, especially if there's a second or third marriage and you have children or family members that you want to protect from your first marriage. It's just really something that's very important. In fact, a lot of our trust documents, we have language, if it's a joint trust or if it's a couple that's creating trusts, a married couple, we include what we call remarriage provisions so that if a spouse passes away and the surviving spouse gets remarried, our trust will oftentimes it's up to the client if they want to include these, but most clients actually do opt in to have these included, where it requires a prenuptial agreement if you want to remain trustee of the sub-trusts, or if you want to even be a beneficiary of the trust, it's requiring a prenuptial agreement for a second marriage. And that's really just to protect your children from your first marriage. And you want to make sure that the plan that you're creating now, if you pass away, it still is going to be effective for the loved ones that you're trying to protect and provide for. So these are just important documents, but again, important to think about in advance and with enough time also, because oftentimes if you do it the night before your marriage or the week before, they're not going to be recognized because it's considered under duress. So you just want to make sure you speak with an attorney and have these documents reviewed and prepared with plenty of time.
So we have a series of articles that I've been writing called Conversations About Money and the essential conversations that people need to be having. And I've just written an article that's going to come out soon, which is about prenuptial agreements and how to have the conversation and when and why you use them. So more information there if you need them. And, this is another way of understanding. So when adult children can understand what is coming to them in terms of inheritance and dovetailing documents from one generation to the next makes so much sense. So, if you're working with Deb and she's got information and she knows all about your estate, it's helpful to dovetail in your parents' documents. Now, they may not be willing to change them, but if she can see the documents and understand what's happening, it will go a long way towards helping you have an estate plan that sort of can dovetail with what's coming to you in those forms. So.
Right, because as we mentioned at the very beginning, creating an estate plan, a lot of people, I'll talk to some of my friends and I'll say, you need to get your documents done. And like, oh, well, I don't own that much. I don't have that much and I'm young and we're healthy. But, you don't need to be wealthy to have an estate plan, because first of all, everyone, hopefully your assets are going to grow over time. But even the smaller amounts of money really mean a lot to people. And it's just a way to avoid family discord after you've passed away, because we get it a lot where we have clients say all of our kids get along, and it doesn't matter if they're worth hundreds of millions, if they're worth very little. When there's money involved, it often causes a lot of arguments and family discord. So it's just a way to avoid it. The same thing with a prenuptial agreement, just to have these conversations. That's why when we have it in our document already, it's actually helpful. We've been told by clients saying, well, I'm getting remarried and I can tell my future spouse I have to sign a prenuptial agreement because my family trust already states that I have to. So it doesn't even, they can kind of blame the trust if it's an uncomfortable discussion because it's already in there and they're sort of expected to have this. So these are just important conversations to have and to understand, as you stated, to understand your parents' documents, what's coming to you, because even though you feel like you don't have a lot of assets now, you might be receiving some at some point in the future, and then your own growth and wealth over time.
Yeah, and I think it's that we've got the silent generation before the baby boomers, and they really were the silent generation in terms of money. And I've worked with so many families who have had no communication about money and feel that it's their money. They don't want to involve their children. And to the extent that you can get those conversations going, it can be incredibly useful, because you may have no idea what's coming to you or what issues they're facing that you may need help with. So that's really important. And I think that it's also important for women to have mastery of these documents, understanding what they say, not just who you've appointed, but how this all works and what happens here, because they've done studies, and I think at this point, something like 94% of women expect to be solely responsible for their finances at some point in their life. And if you are married to a man, typically you will outlive him if he's in similar age bracket. So those kinds of things are really important. It's not just I have to check this off my list, but understanding it is so critical. And then there's taking care of your kids. So we've taken care of our kids. They're going to graduate from high school. And I don't think parents really understand that without your help and without the proper documents signed, they could be sitting outside, heaven forbid, a hospital room with no information available to them and being unable to make decisions for their child who's incapacitated. So talk to us a little bit about what they need and what happens if they don't have these.
Sure. So these are one of my pet projects here at my office that I just think is so important. These what we call young adult documents. So there's 4 different types that we recommend that anyone that has children over the age of 18, young adult, usually 18 to 25, that age range. Well, a will, but actually a will is one of the least important ones. We always think that it's more of the power of attorney, healthcare proxy, HIPAA, and a FERPA release. So a will is important if they wanted to name beneficiaries and who would take care of their assets. We kind of already covered that. Power of attorney, naming parents as their power of attorney or a trusted adult. This is important because it helps you manage somebody's financial affairs. I have a 22-year-old son, and I've used all of these documents other than the will, thankfully he's alive, and they've all come in very handy when my son was off to college. A power of attorney was useful for me because he got a bill a credit card bill. He doesn't understand, or maybe he does now, but initially he didn't understand the importance of credit. And so he had a credit card bill come in. There was a late fee. I tried to call. They were like, we can't speak with you. He's 18. So I was able to share the power of attorney because he had named me as his agent, and I was able to help. Healthcare proxy also came in useful with my son because he had mono as a freshman, which a lot of freshman students do. And he was hospitalized, and I was trying to find out what was going on, and he wasn't really understanding what was going on. And so I was able to speak to medical doctors by sharing the healthcare proxy and the HIPAA release because he had given me permission. And then finally, a FERPA release. So that's a release for allowing you to have access to your students' school information. So things like bills, but also attendance, grades, being able to speak to an advisor or an academic advisor if needed. So these are all documents that are just so important as a parent because we're so used to helping our children and caring for them. But once they actually hit age 18, we've lost any kind of legal control or legal ability to have access. So this is one of the things that we offer at our firm. So actually for anyone that's attending today, I'm going to offer these for free as well. We do these documents, we have them available for anyone that has a young adult. They just need to have it signed in front of a notary, and they can name an agent to be able to help them with all of these issues. Just, during the time where they're still growing up, and but they still need help, but they're independent, yet they're not quite independent. So these are just such important documents. My son had a friend that was in a terrible accident when he was a freshman in college, and they didn't have these documents in place. And so they had, they needed an emergency guardianship meeting appointment because they weren't able to make medical decisions for their son who was in a coma. So it's just, these are things that you really hope you don't need, but just really important to have in place. So that's one of the reasons why we offer these for clients, children, and we'll offer them as well for anyone that's attending today, just because we just feel like these are just so important to have.
So we talked about this a minute ago, and really need to make sure that people are funding their trust. So taking the documents that you've created and changing the titles on your account so it reflects the name of the trust. And putting your house in trust is an important piece of that. It's a big asset. And working with someone like Deborah, she can help you do that and re-register that deed. And just making sure that everything is coordinated. So have your advisor talking to your estate planning attorney, get the copies of the documents to your advisor, and just making sure that information is really flowing back and forth. So the more collaborative your advisors can be, the better result you're going to have. And it's helpful for them to coordinate and to communicate. And if they're not doing that naturally, be the one to suggest it and make sure that information is happening.
And it doesn't need to be a complicated process. If your team is working together, it can be a pretty seamless process to fund your trust. It's not really complicated. It's a matter of filling out some paperwork and some forms. But if you have a team that's working together and understanding the goals, it can be done very quickly and seamlessly.
Yeah, and they'll make sure it happens, and they'll practically do it for you other than the signing.
Yes.
So somebody's come out of your office, they're marched along, they've got a great estate plan in place. Talk to us about what happens next and what things should be updated and when.
We always encourage our clients to stay in touch. We have a program where we continuously meet with our clients every 3 or 5 years. It's just important to update your plan when there's any changes in your family situation. If you have a family member that turns age 18, if someone gets married, gets divorced, if you have children, grandchildren, you're entering retirement or a change in career. Also, just as we stated for the power of attorney and sometimes the healthcare documents, just to update those, just to have new dates so that no one can challenge them or just sort of doubt those documents and give you a hard time if you need them. Also, if your estate grows, if you right now, if you don't have what you think is a lot of assets, but over time you may, then you might want to add some provisions or different types of trust to try to minimize taxes, to reduce your taxable estate. Also, health matters and aging. So as you get older in age, or if you have a diagnosis and you are concerned about long-term care costs, that might be a time to start thinking about other types of trusts. And then also, if there's changes, if you've named somebody that as a trustee or as an agent, as your personal representative, and they've moved to another country and they're not available, if they've passed away, if they've become incapacitated, those are always important times to update your documents. And then of course, new laws, which is one of the reasons why it's just so important to have a relationship with an estate planning attorney, because there's always new laws that come into play that can really impact your intentions. So if you've done an estate plan and it's been 15 years and you think they're all set, most likely they do need to be reviewed, and just to make sure that they still follow your intent and nothing comes up that you weren't aware of, or sadly, if you're no longer around, that now your family has to deal with during an already difficult time.
Yeah, so we go over people's estate plans every year, making sure that we're at least sliding a summary, often, from someone like you, in front of them to make sure that they're reviewing their appointments, that their relationships are still intact in the way they want, and that the, percentage to different beneficiaries or charities or whatever remains the same, because so much of that changes over time. Our lives aren't exactly static. So, what's happening here? I seem to be locked out. Here we go. So there's our fabulous disclosures for both of our firms that everybody needs to know and understand. They're available on our websites. And wanted to put up our contact information here. It was very generous of you, Deborah, to offer those documents for the 18-year-olds. I love that. Thank you very much for making that available. And in terms of questions, so one of the questions I have here is, this seems like a complicated process. How long does this take?
From start to finish, I mean, it really depends on the circumstances, but usually it's no longer than a month to month and a half. We typically have 3 meetings. One is our first EP meeting. We call it our first estate plan meeting, where we just get to know the clients, find out their wishes, what brings you in, what's your concerns, what's going on, learning about your family, making recommendations. So that's the first meeting. And, a client may leave knowing exactly what they want, or they might need more time, and that's fine. So that's our first meeting. Our second meeting is what we call the design. So once we've sort of decided, okay, this is the type of plan we're going to be working on, we get together again and talk about the different roles and the decisions to, as far as ages for your children, as far if you want them to receive an inheritance and what age, what are the different agents, who's going to have a role in your documents. So that's what we call the design meeting. And then finally, it's the signing meeting. So the documents are prepared. We go through them in detail. That's even still an opportunity to make changes, and then they're signed. So usually it's about 2 weeks between each of these meetings. So anywhere from a month to a month and a half. Not as complicated. Once you get the first meeting in and you start to understand the goals, it's a pretty quick process. And oftentimes we even rush them along if there's an event coming up that someone needs them quicker. Depending on the time of the year, we can usually get that done as well.
Yeah, and I think it depends on how available your clients are too, right? So that's helpful. But I really wanted to thank you for today. Thank you for your expertise, and really enjoyed talking to you, and hope that clients who have questions will contact you. And in the future, this information will be on our website so that people can come and access this information and come back and see you and get your contact information. So check back on our website. This will be available. Thanks so much.
Thank you so much, Deborah. This is great, and I love this opportunity.
Thanks. We'll talk to you soon.
Bye, everyone. Thank you.